item 21. Okay.
I have instruction not to press the matter.
The Alhazuddin, learned counsel for the petitioner, submits that he has instructions not to press for this matter. Accordingly, the bail petition is disposed of as not pressed.
I am obliged.
May please lordship. Item number 5, admission 407 criminal petition. My lord, they filed the respondent number 2 filed the affidavit in opposition.
Mhm.
So it is not in the record. So
Okay.
maybe fixed on 2nd of April, September.
September.
Wednesday next.
Mr. R. Deb, learned counsel for respondent number 2, submits.
Extra respondent number 2, lordship.
You are for
Respondent number 2.
2. What's that? Oh, sorry. You are for the Mr. Paul?
Petitioner.
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 Learned counsel for the petitioner submits that you have filed an affidavit.
I have filed
So,
affidavit.
The affidavit filed by the respondent number 2
My lord.
has not yet come into the record, and accordingly seeks for posting of this matter on 2nd September. Prayer is allowed. Any interim order?
No interim.
My lord,
Please
in
the
registry to
okay. I'll fix it on second
2nd of
2/9.
and the affidavit to tag with
Yes.
this.
The affidavit may be brought into the record.
May it please your lordship. It's regarding item number 13 of today's list. The case diary of this in this matter has not been received yet. So kindly matter be taken on 3rd of September this year, lordships. Last again, this honorable court directed to list the case today, your lordship, for case diary. Since the case diary has not been received,
It is submitted by the learned counsel for the petitioner that the case diary is not yet received. Issue reminder for the same. List on. Will it come on 3rd? 3rd 3/9.
this Bongaigaon Abhyapuri, your lordship.
Oh.
Fix it on 3rd, your lordship. Lordship, deeply.
May I please, sir? So, back to mention item number 35, my lord. From motion column, my lord. Can this matter be taken some other day, my lord? Possible for the day, my lord?
Motion matter.
Some difficulties, my lord.
The Bora learned counsel for the petitioner prays for adjourning the matter today. Any specific date?
No, that, my lord. Kindly, my lord. We'll mention it
During the
for the day, my lord.
prayer is allowed. List after week. On a date to be fixed by registry.
Other item, item number 15, my lord.
Another item.
POCSO matter, my lord. Although this is not charged sheeted, my lord. By mistake, this LCR has been called for, my lord. So only CD and notice.
Okay. CD is called for.
CDA was earlier not called for, my lord.
Oh, I see. Yes. It's item 15, Mr. Bora, D. Bora submits that this case is still under investigation and therefore CD has to be called for at
Right.
this stage. Also, issue
Notice has to be issued.
issue fresh requisition for the case diary of Silomo, so and so PS case number. And further steps upon respondent number 2 shall be taken by the prescribed proceeding.
My lord. Deeply honest.
List after,
Yes, my lord.
can suggest a date or
On my lord.
time
14th
frame.
of September.
14/9.
My lord, can you on 9th, my lord?
It
Ninth.
can be, but I don't know how many matters are fixed. Do you want it on 9th,
9th, my lord.
9, 10, 9, 9?
Deeply honest. From Azra, my lord, that's why. Obvious.
Lordship, I beg to mention item number 30. Kindly adjourn the matter further day.
Item
30, 30.
30. Okay. Criminal appeal. Not reach also anyway. Not counsel for the appellant. Praise for adjourning the matter today. When do you want it? After
After 1 week.
26 matter. Okay. After list after 10,
Any date maybe.
list after 2 weeks. 2 weeks on a date to be fixed by registry.
Must.
May it please your lordship. I beg to mention listing of one bail application, lordship.
Okay. When?
Tomorrow, lordship, for
Tomorrow?
withdrawal.
Huh?
Withdrawal, lordship.
Withdrawal I can fix, but otherwise
For
a lot of
lordship,
matters.
I beg to mention item number 10 as well, lordship. Can it be after a week, lordship? Here is come, lordship.
Praise for adjourning, allowing the prayer of the learned counsel. Matter may be posted after a week. Any date?
Lordship, I'll mention.
After a week. Scan TCR is available.
Deeply obliged.
Please, your lordship. Lordship, I beg to mention item number 19.
Okay,
Can we adjourn the matter today and fix the matter on 21st?
interim order is there. Interim order is there.
Yes, interim is there.
I think it will be too long if there is interim order, isn't it?
Earlier CD received my lord returned for updation.
Updation. Take it a little earlier. Can suggest a date also for her. 21st, won't it be a little long? 21st of September,
Yes,
20 days or something.
21st is my lord holiday.
A little earlier, maybe.
On 15th,
15th is okay. 15/9. Interim order passed to and so stands extended till the next date of listing. Issue fresh requisition for the case there.
May I
Yes.
please, your lordship?
Yes.
I beg to mention items number 2 and 3. I have taken the consent of the other side.
That's it.
The matter may kindly be adjourned after 2 weeks.
Order. Wait.
There is an interim order, lordship. I pray, lordship, it may come up on 3rd, lordship.
Just a
3rd
minute, just a
September.
minute.
She has
You are for the appellant, petitioner?
Yes, sir.
You're for the
Yes, your
petition?
lordship.
You're
The
for the-
interim order may kindly be continued
Yes, just a,
in item number
so
3.
you want it after 2 weeks?
Yes.
2
Yes,
weeks.
sir.
You want it, so there's a difference between,
Actually,
somewhere in
last night
between
she
you
has
take.
called me, lordship. I informed her senior that it may be fixed since today she has a problem.
Mhm.
So I pray, lordship, that matter may be interim order is there, that may be on
We have
5th,
fixed many matters in between these 2 days, very short week next week.
lordship.
If we get it fixed on, say, 7th or something, 7th, 8th,
7th,
7, 8, 9.
7th, lordship, it may be.
Okay, 7. Lord Council, prays for adjournment today.
It may be on 8th, lordship, then it's.
Interim order stands by so and so that stands extended till the next date of listing. List on 8/9. 8/9. no? Both are connected. No? You are appearing in both. 8.
May I please, your lordship? So I beg to mention item number 27, lordship. This matter CD was called for perhaps CD has not received, lordship.
Received, my lord.
Interim order is there.
Case diary is not received. 27 item. Issue reminder interim order by so stands extended till the next date of listing. List on
8, 9,
Huh?
8 of September.
it a little later. You give. You can.
Or
We have to make space also.
Oh,
Since
yeah,
there's interim.
16th of September.
15, 16 years.
obliged.
Your lordship, I beg to mention item number 12.
Yeah.
Here in this case, search sheet has been submitted, your lordship,
Okay.
and search sheet number is 208/26.
What kind of matter this is?
Submitted.
Search sheet
No, no, I mean, pardon me, what kind of offense? Because should I take up the matter as it comes? Or shall we call for the scan record? Let me check it.
Conviction under section 75 to your lordship.
No, no, no. Item 12, right? So,
12.
12 is the bail application.
270.
75 to
29, 4,
75.
64, 1.
Scan record will be necessary, I think.
Yes, your lordship.
Item 12. It is submitted that in the meantime, charge sheet has been submitted in the case. In this matter. Pertaining to police case number did accordingly call for the scan TCR comprising case diary and charge sheet from the court of the
CJM
CJM Kamrup M Gauhati list on
No, my lord, CJM Kamrup, my lord, from
Amingaon.
Amingaon.
CJM Kamrup Amingaon list on 14/15 something on
15/9.
15/9.
15.
Search sheet.
You want it on 14th?
15.
15th.
The search sheet number 208/26 dated 31/7/26.
May it please, your lordship. I beg to mention one writ petition criminal for listing on Monday, your lordship.
Bail petition.
Writ petition criminal.
Writ petition criminals. Okay.
Obliged. May it please, your lordship. I beg to mention item number 4, your lordship. We are led by senior counsel Mr. T.N. Chaudhary in this matter. He is having some personal difficulty today. The matter may be kindly fixed on 15th September, your lordship.
The case they received till 15, I may be allowed to return the CD, and again I will get that on that day.
A mention is made on behalf of the senior counsel K. N. Chaudhary. Projecting some difficulty today to conduct the case, full stop. However, the case diary, no interim order is there. Case diary is not received. The learned additional PP submits that he shall return the case diary and procure it again for the next day. List on 15/9 as prayed for.
Give your please.
May I please, Your Lordship? I beg to mention a criminal petition, Your Lordship, on Monday.
No, no.
Last listed on 27/3/2025, Your Lordship.
No, no, not on Monday, listed on Wednesday.
Right, please, Your Lordship. Lordship, I beg to mention item number 8. I have filed a bail objection, Lordship, but it
Okay.
is not.
You are for the respondent.
Respondent, but it is not on record, Lordship. Kindly bring it on record.
Can be brought on record, shall be brought on record.
May I please, Lordship? I beg to mention item number 20, my lord.
20,
20, my lord.
yes.
This case, my lord, PM report was called for, my lord. My learned friend informed the CD was received, my lord. PM report is not, and more so, my lord. The IO has not recorded my statement. In this regard, my lord, petitioner filed one additional affidavit, my lord.
Mhm.
So highlighted her presence in the police station, my lord.
Okay. So the CD has been received.
Report is not available in this.
And his statement also not.
Should we postpone it then?
My lord, he had before died, my lord, victims, that petitioner husband, my lord. That time he was able to speak. And he have stated before the Bongaigaon police IO, my lord, that he had been poisoned, my lord, by the petitioner, my lord. So, my lord, that statement may be called for, my lord, along with postmortem report, my lord.
Stated CD along with PM report.
It appears that the updated CD would be necessary, inclusive of the PM report and what else? The statement of
Made before the, my lord, Bongaigaon police, my lord.
Statement
By the petitioner's husband, my late husband.
by the victim prior to
Succession of what?
his death.
Yes, my lord.
His death. Full stop. That will come in the updated case diary, actually. And additional affidavit you have filed.
Yes, yes, they already filed, my lord.
You have filed.
Yes.
Okay. The petitioner has also filed an additional affidavit which may be brought into the record. The case diary may be returned back and procured again with the necessary updation. Full stop. List on.
My lord, 17th of September.
That much. 17. Any interim order? No.
Yes, there is an interim order.
Yes.
So that will 17 is okay. 17/9/2026. Interim order by so and so stands extended till the next date of listing.
God bless.
Yeah, please, Lordship.
Yes.
Lordship, I beg to mention item number 24 and 25, Your Lordship.
24 and 25.
24 and 25, Your Lordship. The family member of the engaged contracting counsel is in the hospital, Your Lordship. Therefore, he could not present invitation on the board today, Your Lordship.
Okay.
And kindly adjourn the matter, Your Lordship. And Your Lordship, in item number 25, there is an interim order.
Just a minute. 25.
Yes, Lordship.
Item first separately,
continue.
24. The on a prayer, it is prayed for on behalf of the leading counsel that due to some medical issue, the matter may be taken up another day. Also. Prayer is allowed. Scan TCR is available. When do you want it? List
Any
after
date, Your Lordship, except 7 September.
except 7 September. Let it be on 10 September. Then.
Lordship.
10th is a working day, right? 10th. Okay. 10/9. Or it will same order. Only thing is that interim order by so and so date stands extended till the next date of listing. 24, 25.
Please, Your Lordship. Lordship, I have the prayer for listing of a bail application on tomorrow, Lordship, if possible.
Tomorrow we have a very long list actually, So is it an AB or BA?
BA, Lordship.
If it is BA, if you are agreeable, kindly take it on Wednesday.
Okay,
Wednesday.
Lordship.
Huh? Tuesday is a holiday. Wednesday.
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 Okay.
May I please, Your Lordship?
1 and 11 are connecting matter arising out of same FIR.
Pardon?
1 and 11 are connecting matter arising out of.
One
same-
and
In this
11.
case, search sheet submitted, my lord.
One and
11, my
11.
lord. Fixed for 11 is for bail hearing, my lord.
Uh-huh. Both are BA.
Both are well. 78 days behind the bar.
We can take it up together with 11. 27A is also, one is a small quantity.
Small quantity.
And then 27A is also.
7
there.
is there.
Kindly see whether you have the,
No, my lord.
so you have to see the materials, why 27A has been given.
27
Otherwise the quantity is small quantity.
scan copy of TCR has to be complete. Not that many.
Money has been recovered from my position with regards to 27A.
Mere recovery of money would not be 27A. 27A is something bigger.
Yes.
Financing traffic. I will say, do one thing. We'll take it up. Let 11 number item come up. You are appearing in both the cases?
Both the cases.
Both the cases.
Yes, Lordship. By instruction, my lord, CD not received, but scan copy of my lord, the search sheet, my lord, submitted.
One order about it. The petitioner is seeking bail in connection with Murajhar PS case number 105 of 2026. I got to likha hai se to, no? Mr. Bothakur, learned additional PP, submits that investigation stands completed in the case resulting in a charge sheet. You have the number, the charge,
Yes, my lord.
right? CS number, and
PS number
She will take it up.
139/26, dated 16/8/26.
let us see the FIR whether any prima facie materials of 27A is
Search
available.
sheet file under section 20.
Because otherwise, if 27A is not attracted, then it becomes a bailable offense. Small quantity.
20, search sheet
In our-
submitted under section 27.
Under a high court, it's a bailable.
Says search sheet submitted under section 27A also.
Okay,
It will
write
take
down
on-
the sections also, please. Rakesh. Under section,
under section 20B2, 29, 20B2, 29 and 27.
20B2A, capital A slash
Capital
29
A, 29
slash
and
27A, same
27.
sections, same sections, it is.
Or that may be fixed, my lord, scan copy of
Just a minute.
TCR may be-
The section cannot be given mechanically just to, decrease the possibility of bail, but only selling selling is provided for separately.
Yes.
Because all these sections also possession, selling, manufacture, these are covered. It's financing
Financing,
trafficking, financing trafficking. That is different, but here appears to be primarily only selling of illegal drugs. So when can you get it? Murajhar is not so near. It's from Srimubi, I think.
Murajhar Pujai.
Hojai,
Pujai.
Next week.
we have to do that since the
Okay,
section is there.
one more submission I would like to
Yes.
submit. It was not, the contraband was not recovered from my physical possession. Although it was recovered from the campus, it was under the trees.
Mhm.
So it was not recovered from my physical and conscious possession.
So 980 grams of
78 days.
cannabis,
78 days.
ganja. 980 grams should be
78
no,
days
1
behind.
kg. It's below 1 kg. Small quantity only. Good stuff.
I went for it.
The as one of the penal provisions given is section 27A of the NDPS Act. Therefore, the applicability of section 37 of the NDPS Act has to be also seen from the materials. Good stuff. Regarding the other provision of NDPS Act, the same pertains to small quantity. The main allegation is about recovery of 980 grams of suspected cannabis within bracket ganja from the campus of the accused petitioner. There are two accused persons.
Two accused
From
Abdul Khalik and Abdul Khalik is item 11. Vishwajit Namas, Vishwajit,
campus of whom?
Vishwajit Namas Shudra,
His campus.
item 1. Yes.
Full stop. From the campus of allegedly recovered from the campus of accused Biswajit Namasud. Call for the scan TCR comprising Kesdari and Charshit expeditiously from the court of the learned special judge Hosai. Right?
Yes.
Next week we are
8, 9,
7th,
7.
but there are holidays in between. Try and get it. Same. 7, 9. Yes, fine.
Lordship, this matter is arising out of the same FIR as in item number 13, Lordship.
1, 3.
1-3.
We'll wait for that. Then 31.
Item number 13 has been mentioned, Lordship. It is fixed on 3rd September.
Got mentioned.
CD may be called for, Lordship.
That is fixed for CD. On the call for the case diary of Abhayapuri PS case number 189 2026. The petitioner was arrested on 28/7/2026. It is submitted that connected bail application being BA 2282, right, of 2026 is
No,
fixed.
13, item number 13, 230.
Oh, sorry, 2309. huh?
13 no,
Item
Two-
number 13.
2309 bracket item 13 will लिख दो. I got it wrong, mentioned 2309 of 26 is fixed on 3rd of September. Accordingly, fix this matter also on 3/9/2026.
In this case, the son, my lord, the son he happens to be a drug addict, my lord.
Mhm.
Creates havoc in the house
Mhm.
and eventually ends up killing his own father, my lord. Strangulates his father, my lord, because his father was not willing to pay for his drug addiction. Now the mother is also present in the house at the time when this incident happens. So mother goes to the uncle,
Mhm.
the brother, elder brother of the deceased, my lord, and tells him that my son has killed my husband
Mhm.
to initiate action. Now he lodges the FIR, but in the FIR he also mentions me, my lord. The lordship will see the FIR at page 11. Now this is the wife of the deceased,
Mhm.
and she is in jail today. It will be 80 days, my lord.
80 days.
80 days, my lord.
Okay, he says like this.
He says like
And
this.
after
But he
coming
also
to-
admits that I went to his house and informed him.
Mhm. Lanka PS. Difficult.
Bail rejection order of the trial court is at
Any-
page 19.
Take a fresh call. Call for the case diary.
My lord. Only prayer, my lord, can it fix, because today is 80 days, my lord.
Mhm.
My lord, may fix it on 3rd.
It comes, absolutely no problem. Heard Mr. S. Nawaz, the counsel for the petition. Call for the case diary of Lanka PS case number 120 of 2026. Petitioner, stated to be the wife of the deceased, was arrested on 9/6/2026. Her son was also arrested.
He's also in jail.
Released the matter on 3/9.
Let us call for the case diary.
Yes, call for the case diary.
I'm DPO.
May I please, your lordship? This is a 482 application, lordship. The FIR is on page 19. The whole issue, your lordship, is here is the demand of an amount of 2 lakh rupees.
19.
Which page 9. Yeah.
It was 9.
Page 9 is a FIR type copy. The issue here, lordship, is that there was a demand of rupees 2 lakh rupees which I refused to give to the lady. for which she filed this FIR. In fact, regarding the demand of money, I complained before the police, but they didn't do anything. So I filed a complaint before the SP. This is at page 17, Your Lordship. In fact, no medical has been done to confirm regarding this allegation.
Okay. So this is the FIR lodged by her, is
yeah.
that page 9?
Fine.
I've gone through, flipped through it. And then you lodged a complaint before the SP.
First, I lodged before the police, but
Okay.
they didn't take any step. So I filed a complaint before the SP. My mother filed actually. No medical.
Prior to the lodging of the FIR. Prior to the
Yes,
lodging,
Lordship, yes.
you filed the complaint on 2/6.
Yes, Your Lordship. Yes,
What is the date of the FIR?
it's 25,
6.
25/6. Your Lordship.
No, this is 1/6. Next day you filed the complaint. I think if I'm not mistaken, it's 1/6. Kindly see page 12.
FIR on 1/6.
I think it's 1/6, yes. Anyway, so
Humble prayer, Lordship. In the meantime, I will be protected, Your Lordship.
ritual criminals.
Well, victim is a married lady, and my lord, her contents and the
I find the FIR slightly confusing.
Yes.
Slightly, plots here.
otherwise
Anyway,
those my lord, application before the SP, my lord, whether he has.
okay, you can record your statement. We can help you.
My lord, from the contents of the present FIR lodged by the my lord victim,
Uh-huh.
she has made lots of allegations, not only my lord.
Yes, but there are some
Continuously, my lord, the accused person.
there are
is
some
involved in
confusions
it.
also. There are some, if you look at it carefully,
Yes.
I've seen some. Maybe I'm wrong also, but
Yes.
there appear to be some. Anyway, let him record his statement. At this stage, since he is a major, heard, call for the invoking 482 BNSS. The petitioner is seeking anticipatory bail in connection with Doboka PS 68 of 26, the so and so section. The case was registered based on an FIR dated 26/5/2026 lodged by the alleged victim woman, indicating her age as 23 years, also stating her to be married and working in a medical company. The gist of the allegation is that he was facing some disturbance from the side of the petitioner, and subsequently she met him. There is also allegation of assaulting her, sending one of her personal photograph to her husband. The learned counsel draws attention to the date to column FIR dated 1/6, FIR dated 1/6/2026. The learned counsel has drawn attention to a complaint lodged from the side of the petitioner before the superintendent of police Hojai. So though the said complaint is dated 2/6/2026, that is one day after the date of the FIR, but it also makes some allegations against the informant and another person within bracket male. The petitioner, this number 2 is not her husband. Her husband?
Number two, her husband. Your Lordship.
Her husband?
No,
Not her husband.
no,
Not her husband.
This is a nexus, Your Lordship, demanding money from the people.
The gist of the allegation in the said complaint is about threatening and demand of money and threat of false implication. Next paragraph. Call for the case diary. In the projected circumstances, I am of the considered view that the petitioner can be given an opportunity to record his statement and his version of events. In such view of the matter, is directed that 25,000 with one surety. Satisfaction of arresting authority, subject to the condition, cooperative investigation. Make himself available for examination before the IO. Number 3, shall not cause any harm or intimidation upon the informant. List on 17,
17 years.
17.
Lordship, a small prayer. My name may be reflected in the order.
Yes,
I am it.
then I have
Deep level.
it will be reflected, no problem.
Wait, please, Your Lord.
Yes.
Here is bail application, madam. FIR is at page number 31.
31.
May I read the FIR, madam?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 22/3/26 তাৰিখে ৰাতি অনুমান 10:30 বজাত এজাহাৰকাৰিণী ঘৰত অকলে থকাৰ সুযোগ গ্ৰহণ কৰি তলত উল্লেখিত আসামীগণে অনাধিকাৰ এজাহাৰকাৰিণী ঘৰত প্ৰৱেশ কৰি বাকচ ভাঙি 5,000 টকা আৰু সোণৰ আৰু খাৰু লুটপাট কৰি লয় আৰু 1 নম্বৰ আসামীয়ে বাকী আসামীগণৰ লগত মিলি এজাহাৰকাৰিণীক ধৰ্ষণ কৰি শৰীৰৰ বিভিন্ন অংশত গুৰুতৰ জখম কৰি পলায়ন কৰে আৰু লগতে প্ৰকাশ কৰে যে আৰক্ষীৰ ওচৰত কোনো ধৰণৰ গোচৰ কৰিলে ধৰ্ষণৰ গোপন ভিডিঅ' সামাজিক মাধ্যমত প্ৰচাৰ কৰিব। প্ৰকাশ থাকে যে বুজাবুজি পৰামৰ্শৰ বাবে এজাহাৰ দিয়াটো পলম হ'ল। Now, my lord, the accused are Jahangir Hussain, Bilal Hussain, Momidul Haq, my lord. Now, my instruction is that, my lord, this Jahangir Hussain, my lord, had a relationship with this Noor Nahar Begum outside their marriage, my lord, extramarital affair, my lord. Now, my lord, why this affair was lodged, my lord? Lordship will now kindly have a look at this page number 17. 17, my lord. The vernacular is at page number 22, my lord. It's not very legible, my lord. So 17 is the, my lord, translated copy. This was lodged by one Mujahidul Islam. It says that, my lord, in the year 2025, my lord, with due respect, I beg to state that on 21/9/2025 at around 11 p.m. at night, my elder brother, after closing his grocery shop at Sariali Market, had gone home and was sitting idly at the veranda of her house after having his meal. Before that, the below mentioned accused persons went to the shop and discussed that today fish will be found in the river, therefore we'll go to catch fish. Thereafter, taking my friend Momidul, that is, my lord, the accused number 3 in the present FIR, my lord, went to catch fish. Thereafter, when my elder brother is the accused number 1, was catching fish, he was grievously injured by attacking with bamboo, stick and iron from behind and thrown at Adholi Chor. After that, when my friend Momidul opposed, he was also attacked him. Thereafter, when Momidul ran to inform the villagers for their rescue, the above mentioned accused persons prevented him from going. Thereafter, police personnel rescued the above mentioned persons and sent them to Halakura Hospital. Now, Lordship will kindly have a look at serial number 6, my lord, Khurshid Alam. This Khurshid Alam, my lord, happens to be the brother-in-law of the informant. If your lordship will see page number 31 again, my lord, the present FIR, the informant was Noor Nahar Begum.
Where is the translated copy of the FIR?
31, my lord.
31. No, the translated copy is there.
The earlier FIR, my lord.
No, the
Present FIR, 31, my lord.
So 21 is the vernacular, actually.
Vernacular, my lord.
In my
Translated,
petition.
my lord, is
If it is there, otherwise we'll manage.
at page number 26.
It was lost by
Lodged by Noor Nahar Begum, my lord. Now, Noor Nahar Begum, my lord, is the wife of Abdul Mannan Sheikh.
the accused number 6, Farisud Alam. He's the
Yes, brother of Abdul Mannan Sheikh. And to prove
brother-in-law of the informant.
yes, to prove the linkage, my lord, Lords will now come to page number 36, the voter list, my lord. Or, my lord, page number 38, the vernacular, my lord. Last page. That is Khusmot Alam, Abdul Mannan Sheikh, and Noor Nahar Begum, my lord. Second.
This is
So, our instruction is that, my lord, just to escape prosecution in that case, my lord, they have, my lord, lodged this present FIR, my lord, against the victims of that case, my lord, making them an accused in this case.
They were opposed to their relationship, my lord. That is why, my lord, earlier also their family members along with their friends, my lord, tried to attack the accused number 1 of this present case, my lord, because he and the victim, the informant, was having an extramarital affair, my lord.
Who? Just let me go through
The
this
accused
thing.
number 1.
Accused number one.
1.
Hassan Jahangir.
Yes, he and the informant, Noor
Informant.
Nahar Begum.
Okay. Whatever it is. Some illicit relationship.
Yes.
And thereafter it was opposed by
The family members, my lord, including the husband. Definitely, my lord, naturally they will oppose, my lord. And that is why they had attacked these persons, my lord, in the year 2025, because of which that affair was lost, the earlier affair. My lord. And they also got bail in that affair. My lord.
8 persons were named in the affair.
Yes.
And the
Postmortem.
Kharisad Alam is the brother-in-law of
Brother-in-law of the
informant.
informant, Noor Nahar Begum.
And the informant here, Mujahidil, is
He is the brother of the, well, this one, accused number 1.
Jahangir Hussain.
Yes.
You have stated that. You must have stated that.
That was before that, my lord. Rounded session just for anticipatory bail, my lord. That
Or
was-
maybe at this stage, we can just call for the case diary with a short date.
Yes.
Just through. Because he's basically alleging false implication.
Page 34 is the earlier rejection of it. Learned session just.
That's all are named, that's all. The known persons committing the robbery, that is also one question.
Yes.
But anyway. Heard Mr. S. the counsel for the petitioners in number, namely so and so, so and so. And P. Bothakur learned additional PP. Petitioners are seeking regular anticipatory bail in connection with Gologon's PS case number 165 of 2026, which was registered based on an FIR, based on an FIR dated
14/7/2026.
14/7/2026, with the allegations that the 3 accused persons named in the FIR illegally trespassed into her house, in the informant's house, on 22/3/2026 in the night, and robbed ornaments, semicolon, assaulted and injured her. Committed rape upon her, and also threatened to viral some private videos. Mr. Das, learned counsel.
And one more thing, Lordship will note, my lord. The incident, my lord, apparently occurred on 22/3. FIR lodged, my lord, on 14/7, my lord. Delay of, my lord,
Mr.
around
Das,
4
learned
months.
counsel points out that though the alleged incident mentioned in the FIR is stated to have taken place on 22/3/2026, but the FIR came to be filed on 14/7/2026. That is after a delay of more than several months. It raises some questions, no
Yes,
doubt,
my lord.
no doubt. The primary contention of the learned counsel for the petitioners is that they have been falsely implicated in the context of some earlier developments. And in this regard, it is submitted that now you help me with this.
Well,
narrative,
why that,
the correct facts, because I have
in
like,
the FIR regarding that?
I've not fully understood actually the link that on 21/9 to, you're saying something, please?
Why, my lord, the delay in lodging the FIR itself, my lord, from the rejection order itself reflect the accused persons also threaten her that if she lodges any complaints. he
No,
would
that
make
is
the-
there.
Yes, that is the, my lord.
No, per se, the allegations are very serious, no
But
doubt.
the-
You will
but
also
the
agree.
FIR says a different reason, my lord. It says প্ৰকাশ থাকে যে বুজা পৰামৰ্শৰ বাবে এজাহাৰ দিয়াত পলম. That is the ground which they have taken in the FIR.
In the FIR,
Not that one.
let us see.
Last line, my lord.
This thing we
31.
have to see carefully
বুজা পৰামৰ্শৰ বাবে এজাহাৰ দিয়াত পলম হ'ল মানে।
where it is written.
মানে first paragraph last line. 31.
প্ৰকাশ থাকে যে বুজা পৰামৰ্শৰ বাবে এজাহাৰ দিয়াত বুজা পৰামৰ্শ
But had it been a genuine case,
settlement
yes, why would they have waited for so much
বুজা
so many
পৰামৰ্শ।
months, my lord?
What does he mean by বুজা পৰামৰ্শ? Settlement,
Advice, basically.
advice. It is also pointed out by the learned counsel for the petitioner that the delay in lodging of the FIR is being sought to be explained by stating that it is due to some advice. There were some questions, no doubt. Going back to the learned counsel, you bring that below this. Huh? In support of his contentions about false implication, the learned counsel submits that on 21/9/2025, Mujahidul Islam, this informant is now, he is the brother of,
He's the cousin brother of this accused number 1.
who's the cousin brother of accused petitioner number 1, had lodged an FIR about assault and causing serious injuries
Of the accused number 1 and accused number 3 of the present FIR. Momidul Haq and Jahangir Hussain.
assault upon accused number 1 and accused number 3 of the present FIR, naming 6 accused persons in the said FIR dated 21/9/2025. It is submitted in this context that A6 of that FIR, being namely Kharisat Alam, is the cousin brother of the informant who has lodged the
Brother-in-law.
FIR, is the brother-in-law of the FIR dated 14/7/2026. It is submitted that the present FIR has been lodged falsely implicating the present petitioners out of grudge with regard to the earlier prosecution. Full stop. Call for the case diary from the concerned police station along with medical report if any. Full stop. I've given my anxious consideration to the prayer for interim bail made by the learned counsel for the petitioner. Full stop. From the projected circumstances, including the considerable delay in lodging the FIR dated 14/7/2026, which has been sought to be explained somewhat superficially. At this stage, the possibility of any false implication cannot be ruled out altogether. Accordingly, in such view of the matter, I am inclined to grant some interim protection to the petitioners and enable them to record their statements before the investigating officer. In such view of the matter, or accordingly, you can write. It is directed that in the interim, in the event of arrest of the petitioners in connection with this case, allowed to go on bail of rupees 30,000 each. Okay, 30,000 each.
Right.
With a surety of the like amount each, to the satisfaction of the arresting authority, subject to the following 3 conditions at this stage. Number 1, they shall cooperate with the investigation. Number 2, they shall appear before the IO, making themselves available for examination. Number 3, they shall not in any manner cause any harm or intimidation or harassment of the informant or our family members. Violation of the bail conditions will entail cancellation of the interim bail. List on
18/9, madam.
Highly obliged.
BS6.
Yes, Mr. Bhuyan.
My lord, may I please as a lordship, my lord, what we have done, my
sorry.
lord, we have filed an additional affidavit, my lord, to bring the correct FIR, my lord, and that affidavit perhaps is on record, my lord, long.
You're for that?
I'm for the accused person. They have served just now your copy, Lord.
My lord.
No, you're for the informant.
No, he is
This
the accused.
cancellation.
We are praying for
Also,
cancellation
this
of
is
my
a
lord.
bail cancellation. Oh, I see.
My lord.
Okay.
They have served us a copy, Your Lordship. Let me go through it, Your Lordship. And the hour of the second.
Heard Mr. P.R. Bhuyan, learned the counsel, appearing for the petitioner herein. Hmm?
I have received the case.
Hmm?
Case diary I have received.
Petitioner herein seeking cancellation of
Of the bail order dated, my lord.
order dated 11/3/2026, granting anticipatory bail to the respond number
Two, my lord, two, my lord.
in Sangsari PS case number 35 of 26, by order dated 11/3, we've written the order date, 11/3/2026, passed by learned Session Judge Kamrup Amenga.
One.
The learned counsel for the respond number 2/accused submits that though he has received a copy of the bail petition, he has just received the copy of the bail
Copy of
petition.
the additional affidavit filed, my lord.
Okay.
Once.
He has received the copy of the additional affidavit filed by the petitioner seeking bail cancellation and seek some time to make his submissions. Okay. So we'll fix it on when, next week or
Month.
thereafter? Next week we have short, only
Yes.
3 days. Take it on 7th.
My lord.
Lordship, can it be on 10? 10 or 11, Your Lordship?
Delay it also because we have to see the matter, what it is about. 10th
My lord, I don't have any problem.
is the matter on 10/9. Case diary has been received.
Yes.
Case diary has been received. Full stop. What will you do? It's almost more than 10 days. I'm sorry.
Lordship may not record my hearing of the case diary.
The case diary shall be procured on the next date.
All right.
Obliged.
Lord 7.
May I please, Your Lordship? Last occasion
It's recorded.
was called forward. Here, my lord, he was arrested on 10/5, today is 110 days. And case register, my lord, under section 22C of NDPS Act. And my lord, the FIR is phase 14. Here stated in the FIR that the police team came the house where he was residing
Mhm.
and conducted search operation and found my lord,
Cough syrup.
my lord, cough syrup from the courtyard of his uncle's residence. And saying that it was his conscious possession. And personally, he was also searched, my lord.
Mhm.
And saying that section 50 we have complied.
Mhm.
So section 50 whether complied or not, maybe examined. And
So many cough syrups will not be recovered from his personal possession. It is his uncle's house.
No, my lord, within the say. Initially, police arrested him and those
uncle's house.
seizure list, not from, yes, within the same campus, my lord, that is specifically mentioned in the seizure list.
This 14 paragraph
Record is come.
recovered from the courtyard of his uncle's residence. During the sustained interrogation, the apprehended person identified so and so, so and so. And my lord, next page 15. But here one paragraph also, I informed the suspect so and so of his legal right under section 50 of the NDPS Act to be searched in the presence of magistrate or gazette officer.
Mhm.
However, the accused voluntarily stated that he did not require the presence of either. Accordingly, notice under section 50 of NDPS Act was served upon the accused in the presence of the aforesaid to independent witnesses.
Nothing was found from his personal possession.
Yes, Caesar list I have my lord flag mark my lord in the record. FSL report also received confirming presence of codeine phosphate.
What is the stage of the case now?
Sheet submitted TCR received my lord.
No, trial has started. Trial has started. No.
Evidence is not examined.
Charge frame.
Charge
For your,
Such payment. Consider my lord, he will face the trial.
First frame motion.
First occasion, no?
charge framed.
Professional person. Which person? Letters person.
This should be commercial quantity, 149.
149 bottles.
Codeine has a formula, right? In
I have flag mark my lord in the TCR.
each bottle containing 100 ml and weighing approximately so and so.
That's one, no?
Difficult is the-
Stars yet not
Difficult-
frame, my lord. Date fix was today, my lord.
Next one. The difficulty, Mr.
Today's
Uddin, is the, as you would
date
know, is the 37. These are witnesses on all that?
Yes.
They are there? Thirteen witnesses are listed.
On Majidul Islam, Razibul Islam, and Mustaraf Hussain.
Forensic report is received.
I received mail confirming codeine mail. FSL report I have flag mark.
Where is it? But the statements of the Caesar witnesses are necessary. I think I did not find, otherwise we'll have to call for it since 37 determination requires that. It requires that. You can have a look, but I could not find. The FSL is there. FSL
Is there, mail confirming presence of codeine.
Kindly check. I could not find, otherwise we'll have to call for it. 80% call. Go down. There's another copy, might be here. No, I think it's here. Just too much. Vector. Here. It's here. In this second volume it is there. Supported. The allegations are there. Bit difficult. This is in Borpeta. Right?
Corporate man.
So Anne would be learned counsel for the petitioner. And P. Bhattakur learned additional people. Invoking the provisions of section 483 BNSS. Have a seat, please. Mr. Udin, you can sit down. 483 BNSS. The petitioner, namely Azizul, seeking regular bail in connection with Kalgosia PS case number 47 of 26, which was registered based on a FIR dated 10/5/2026, lodged by police official of Balikuri Police Outpost under the said police station. The allegations in a nutshell are that on the same day, in the very early hours, information was received about the petitioner dealing with and selling codeine-based cough syrup, Ving Coffee, VINCOF dash capital TK in this area for a considerable period of time. Accordingly, GD 22 of the same date was made in the Kalgosia police station, and a search operation was initiated. Subsequently, upon conducting the search on carton of such containing such Vinkov TK cough syrups were recovered in the courtyard of his uncle's residence. However, during further interrogation, he disclosed that the said contraband belonged to him and was intended for illegal sale in the area. Three witnesses have been mentioned in the FIR who were requested to participate in the search, and they accordingly did so. Stuff. The petitioner was arrested on the same day, that is 10/5/2026, presently in judicial custody. Completion of investigation resulted in a charge sheet under section 22C of the NDPS Act, and the case is presently stated to be pending at the stage of trial before the learned special judge Borpeta by way of special case number NDPS case number 45 of 2026. So the scan TCR was called for and received. The learned additional PP submits that the investigation has revealed incriminating materials against the petitioner due to which the charge sheet was submitted. It is also further contended by the prosecution that the sample which was sent for FSL examination returned positive finding for codeine. The quantity of the psychotropic substance found in the 149 bottles which were purportedly seized at the time of the incident is stated to be falling in the bracket of commercial quantity of psychotropic substances under section 22C of the NDPS Act. Full stop. I find from the record that 13 witnesses are listed in the charge sheet. The three purportedly independent civilian Caesar witnesses who were mentioned in the FIR have supported the allegations in their statements recorded during investigation. I've carefully perused all three statements, and all the three witnesses have stated about the allegations regarding the seizure of a carton of cough syrup containing 149 bottles. Stop. I perused the inventory documents as well as the FSL report. Stop. The statements of other witnesses, including some members of the search team, are also incriminating in nature. Full stop. In the circumstances, considering the applicability of section 37 of the Act, full stop, it is not possible to say that there are reasonable grounds to believe that accused petitioner is not guilty of the alleged offences. Therefore, the rigors of section 37 comes into play, prohibiting grant of bail at this stage. Therefore, there is no option but to reject the bail at this stage, and it's accordingly done so. It is clarified that whatever is mentioned here is only for the purpose of adjudication of the bail petition and should not be taken to be expressing any opinion on the merits of the case pending for trial, either to the prejudice of the defense or the prosecution. The bail petition stands dismissed and disposed. One line you just read, the learned trial court shall endeavor to expeditiously conduct and complete the trial. That's all you can say. Bill.
That please also. It's a regular bail, my lord. And your lordship will find that, my lord, this petitioner is behind the bar, my lord, for 117 days, my lord. In fact, SARS is also framed, my lord, on, my lord, 24/06/2026, my lord. SARS has been framed, but, my lord, no evidence is recorded till date. 24/06/2026.
SARS framed that
SARS framed.
witness examination not started.
Not yet
Not
started, my lord. Though dates are there, my lord. Several dates are there, my lord. But nobody is coming, my lord, for recording their statement, my lord. In fact, your lordship will kindly come to page 10 is the FIR, my lord.
Yes, I'm on 10.
It's a consensual relation, my lord.
16 to 18 years. Clinically. Yes. What else from your side before I
Uh,
go to?
Page 10 is the FIR, my lord.
Yes, I've seen the FIR.
Yes, my lord. In fact, my lord, your lordship will see, I am reading out, my lord, for your lordship's consideration, my lord. With respect, this is to state that at about 11 o'clock in the morning on 24.
Don't take the name of the girl. No?
Yes, yes, they are aware, my lord. The parents are, they are aware. Now, see, he has been immediately arrested in the case, my lord. And your lord, and my lord, search sheet has also been, my lord, laid, my lord. And your lordship kindly come to, my lord, page 21.
Of your petition.
Page 21, this is the charge. Down below, my lord. Page 21. This is the translated version of the search sheet, my lord. In reference to the case, to medically examine the victim and to give her in safe Zimmer. I am skipping this, my lord. Your lordship kindly come to, my lord, page 22, my lord. Page 22, my lord. Last, my lord, fifth line. Last fifth line starts, my lord, victim so and so. Last fifth line of this para, my lord.
Okay.
Victim so and so who is having no birth certificate and school certificate could not be seized. So prosecution, my lord, IO could not, my lord, seize any document, my lord. But determination of age of victim is mentioned in the X-ray report. Thereafter, the medical report of the victim has been collected, wherein medical officer's opinion is as follows. Clinically, her age is about 16 to 18 years. No evidence of recent sexual intercourse, no visible injury at her body or private parts. The medical examination was done on 27th, my lord, on which day she came back for the second time. So admittedly, my lord, there is no document to show that she is a minor, my lord. In fact, my lord, your lordship is aware, the my lord, if in the charge sheet, my lord, if there is no any document, then the learned court has to, my lord, go by the, my lord, medical report, my lord. And your lordship is aware that, my lord, when there is any medical report, my lord, with regard to the determination of any, my lord, victim's age, my lord, then there is a variation of 2 years margin, my lord. In that way, my lord, she is a major, my lord. She seems to be a major, my lord.
Has he supported any allegations in the 160, 180, 183
Yes,
statement?
183, my lord. She is a student of.
You're for the informant, right? Am I a question of private counsel, privately in case? You filed an objection, no? Written objection.
In her
I'll come to it.
183
I'll come.
BNS, her age was recorded as 17 years, a student of class 8, my lord.
But first and second paragraph, my lord.
Only come to the directly to the 183 statement.
I'll come. Just one. He wants to show the thing. Page 18. I'm on page 18.
Yes, my lord. May I read, my lord?
Okay. Accused. There are two accused named, no? Including 200 other villagers.
Yes, my lord.
Informant is
And
Khelang
the accused
Terang.
number two, four family members.
Hmm?
Accused number two, four family members.
His wife and 4 family members. Many people have been indicated. Okay.
My lord, FIR will see, my lord, first and second paragraph, my lord, that will show the allegation against me, my lord. May I kindly elaborate? With due respect, I would like to state that past few days back, accused number 1 has seen a dream that my son, that his son, namely so and so, has slit his throat. Accused number 1 has spread this news among the villagers and instigated them. After that, he had visited Upper Tiopani in the temple of accused number 2 and consulted about the matter, and accused number 2 declared that and my family members are worshipping Kali Ma and planning to kill the accused number 1 with supernatural powers. Thereafter, on 1/7/2026, the Kambora, that is accused number 1, along with the villagers, took me, my wife, my son, daughter-in-law, and brother, including other 12 family members, were taken to the temple of accused number 2. It was on about 11 p.m. when we reached the temple. After that, accused number 1 and the villagers forced us to plead guilty. No matter if there is rain or sunshine, or else we won't be allowed to return home. Now, my lord, next my incident will come up, my lord. On 2/7/2026, when my pregnant daughter-in-law and son were returning home about 7:30 p.m., the villagers forced them to accompany them again to the temple of accused number 2 and threatened them to plead guilty. On 3/7/2026, the Kambura and villager arranged a meeting at about 11 p.m. and decided that we must leave the village within 2 days. This must be noted, my lord. According to them, we must leave the villager on 6/7/2026. On 6/7/2026, my daughter-in-law gave birth to a child despite knowing our difficulties. At about 1:30 to so p.m., the Kambura and the villager compelled us to leave the village, including other 12 family members. Having no other option, we took shelter in the house of so-and-so house whose residence is at Ila, and we are still staying there. My lord,
This is the allegation.
my contention is, my lord,
On entity statement also, lordship.
As you know, from the point of view of this law, more than the pleading guilty aspect, the more problematic part is forcing them to leave the village.
That is it.
that is there it's very unfortunate, my lord. But what is rule against me, my lord? If lordship permit me, my lord, I am a resident of Tupani, my lord. My position is as a priest, my lord. I am a temple in a priest. Now,
Your
occurrence took place in
your
different.
accused number 2.
Accused number 2. I am a priest, my lord, in the temple of Tupani. Occurrence took place in different village, my lord, under different police station. Neither I was there at the place of occurrence or I visited. Neither, my lord, what behind is that, my lord, this informant and the villagers, his villagers, that is accused number 1 and 200 others, they on 1, my lord, as it reveals, my lord, on 1, my lord, they came in my temple, my lord, having some dispute, my lord. Therefore, all I suggested is I am a religious person. I have nothing to do with the dispute. I cannot resolve your problem. Please, you resolve amicably, settle between yourself. I cannot interfere in your problem, my lord, in such criminal activities. All fairly, I suggested them. And my lord, on 2nd, my lord, that occurred on 1/7, my lord. On 2nd, my lord, this incident has taken place, my lord. Had it been, my lord, with all respect, my lord, if at all, my lord, this incident occur in the temple, inside the temple at all, my lord, why they have not filed FIR immediately thereafter? Then only on 2nd, my lord, on 2nd, 3rd, 6th, all consequently thereafter, my lord, when meeting has been conducted and it was decided, then, my lord, I only tasked, but subsequently I was implicated here, my lord. Therefore, I have no at all rule, my lord. FIR was lodged even after much delay, my lord.
When was
It reveals, my lord.
What is the date of the FIR?
11/7, my lord.
11/7.
Yes, what we have been doing, my lord. If at all, my lord, occurrence took place, I am involved in the offense on 1/7 when they visited my temple, my lord. What they have been doing? They should have filed a FIR, my lord.
Charge sheet file, lordship.
Charge sheet is there, my lord. I will, my lord, I will indicate.
Not yet found, lordship.
So I think maybe.
My lord,
SL part is not there, lordship. SL
No.
part is there in section 9 will not count, lordship.
SOL is not there, my lord, as per one
Born out of superstitions, but if there was violence and all thing, then there was something
They
serious.
compel him to leave, them to leave.
But kicking out of the village is that not be done.
My lord, there is a old crutches, my lord, as it reveals for my lord, annexer, my lord, annexer C, page 27. There is a, since 2016, my lord, this accused person, informant, and the villagers are having dispute, my lord, since 2016, my lord. And this is a continuous process, my lord, as it, my lord, reveals, my lord, as I understood, my lord. My lord, if
we impose some conditions.
yes, my lord.
Okay, no problem. Your Mr.
My lord, N.K. Muri, my lord.
and Kamuri,
Yes.
learned counsel for the petitioner and learned additional people. Collaboratively. 19/8/2020. The next paragraph. The gist of the allegations in the FIR dated 11/7/2026, lodged by informant Khelang Terang, naming two accused persons, including the present petitioner and unnamed villagers and family members. The gist of the allegations is that the allegations is that the present petitioner as accused number 2 had declared that the informant and her family members were using some worship and supernatural power to kill accused number 2. Accused number 1 in the context of the same, subsequently, the informant and her family members were compelled, were taken to the temple of which the petitioner number 2 is the priest and forced to plead guilty. It is also alleged that subsequently they compelled them to leave the village despite the fact that her daughter-in-law had just given birth to a child. The present petitioner was arrested on 13/7/2026. Investigation resulted in a charge sheet and registration of special case number 3 of 2026, which is stated to be at the stage of trial before the learned special judge Karbi Anglong at Difu. A scanned TCR has been received. Upon considering the matter and also the length of detention as well as the stage of the case, I am of the considered view that subject to suitable conditions, the petitioner should be allowed to go on bail at this stage. Next paragraph. In such view of the matter is 30,000 with 1 surety. The satisfaction of
Mobilize, my lord.
learned special judge Karbi Anglong. Following conditions are imposed. He shall be available for the trial, shall not hamper or temporary dividends. He shall not commit any illegal activities or offenses, including any activities or acts prohibited under the Assam Witch Hunting Prohibition Act. Violation of the bail conditions would make the bail liable to be cancelled. Bail petition stands dismissed.
Obliged, my lord.
My lord, city not receipt, my lord.
Your lord.
1 minute, just
Lordship.
checking something.
Allegation against me is 304 of subsection 2, your lordship. In this section, maximum punishment is 3 years, lordship. Lordship, FIR is at page, lordship 9, lordship. I am not an FIR accused, lordship.
4-2.
Lordship, what happened, lordship? In
Snatching.
Snatching of the
gold chain, my lord.
In
Not only the sentence, snatching is it is not an insignificant crime actually.
Lordship.
Because it's very detrimental to public safety.
Right.
Women are vulnerable.
Right.
So anyway, let us look at the case diary.
Lordship,
Short accommodation.
may I submit, lordship? Lordship, as per forwarding, lordship, forwarding is at page 15, lordship.
Page 16.
15, lordship. Lordship, what happened, lordship? The investigation officer has not clearly mentioned anything regarding me, lordship, and linkage to the incident, lordship. Lordship, the 11th paragraph is 3, lordship. The accused was using the same phone that was used in commission of the crime. On 16/07/2016, a call was made from the crime use phone number so and so to Monwar Hussain. I am Monwar Hussain, lordship. Manohar Hassan's wife's phone number so and so. Thereafter, the accused switched off the phone and did not use it again. Later on, so and so, the SIM card bearing so and so, which was being used in his wife's Vivo phone, was inserted into the phone used in commission of the crime. So no clear picture is given in the forwarding report, Lordship. Whereas I am not an FINM accused, in the first paragraph of the ground of arrest, the IO has mentioned that I am a FINM accused, Lordship.
That's fair.
And Lordship,
that is wrong.
Lordship, the punishment is up to maximum 3 years, Lordship. And the notice under section 35(3) was not served to me, Lordship.
How will notice be served in such cases? That is because he ran away. He was, what was this thing? Mobile phone was stolen or
No, Lordship,
chain was Chain was
May I read the FIR, Lordship?
No, it's okay.
Lordship,
it's
in the
here.
FIR, Lordship, no one was identified, Lordship.
On the crime is mobile phone to Manohar.
Lordship, nowhere.
Which Thana?
Lordship, Bholamukh, Lordship.
Please get it. Get it. Get it.
Lordship, last 19 days, Lordship, I am behind the bar, Lordship.
When can you get it, Mr. Boyson?
Second by.
Lordship, on Monday, Lordship.
Yes. Difficult one.
31st, no, Monday.
Monday.
31st.
Monday, whole
31st.
Be on second. That will be better. The case diary is not received. Full stop. The petitioner was arrested on 8/8/2026. Issue reminder for the case diary of Horlumukh PS case number 112 of 26. List on second. 29.
I am a blessed.
My application, Lordship. This is regular bail application, Lordship. Today is 55 days petitioner is behind the bar, but statutory period is 60 days, Lordship. Allegation against me, Lordship, under section 22B of NDPS Act, Lordship.
Diary is
Is they receiving?
This 55 days petitioner is behind the bar, Lordship. FR is 9, Lordship, and 14 is the FIR, Lordship. In the entire FIR, Lordship, it has not been mentioned. This item was seized from this Suleiman Ali. Entire FIR, Lordship.
It was found from his body search.
No, my lord. Yes,
Tramadol hydrochloride.
yes, my lord. Body search.
Containing 8 capsules, nitrozepam.
But from the pockets of his man. Section 50 may complied with me.
Is he peddling? Is the allegations are about peddling or consumption? Because the two things are very different actually. Consumption,
He's peddling.
person has to take rehabilitation.
Consumption.
Otherwise,
He is involved in peddling.
the trust is not criminalization.
From his possession, my lord, those contraband were recovered. Suleiman Chaudhary.
55 days, even is behind the bar, Lordship, petitioner, young boy, Lordship.
What is the progress of investigation? Please?
Investigation will substantially progress now.
Heard booking 483 BNSS.
Only my lord, FSL report not yet received.
I just pass it on to me. You are Mr. Ali.
Ali,
Yeah,
Lordship.
yes. Learned counsel for the petitioner. And you brought her. Last order, second prayer. The gist of the allegations in the FIR dated 5/7/2026 is that information was received at the Fakirganj PS in the district of Dhubri about selling of narcotic drugs. It's about peddling. Allegation is about peddling, selling in the area by peddler. Accordingly, GD entry was made and an operation was initiated. Subsequently, upon certain suspicions, the petitioner was detained and after search, psychotropic substances in the nature of 7 strips of SENPAS, SENSPAS plus and nitrozepam and 2 strips of nitrozepam. Tablets were recovered, whose total weight was 42.76 grams. Full stop. The petitioner was arrested on the same day, that is,
Arrested on 4 lordship.
he was arrested on 4/7/2026. And learned counsel submits that he is completed 55 days in custody. The case diary has been received. Also, the learned additional PP fairly submits that there has been substantial progress in investigation. However, the investigation implicates the petitioner.
FSL report not yet received.
Not yet received. The FSL report is awaited. The medical report annexed with the petition, with the case diary about regarding examination of the victim indicates the noting of the doctor about the patient having a history of taking some unknown pills. He's also into addiction, I think. Considering the progress, despite the implications, considering the progress of investigation, the length of detention, and also an aspect of the petitioner, accused petitioner, an aspect emerging of the accused petitioner himself being victim of addiction. Stuff. I'm of the considered view that bail should be considered at this stage subject to suitable conditions. Accordingly, he's allowed to go on bail of rupees 30,000 you give, one surety of the like amount to the satisfaction of which court?
CJM Dhubri.
CJM, no, it will be special judge Dhubri, I think.
Yes, special judge.
Special to the concerned learned court. Within bracket, special judge Dhubri, and subject to the following conditions. He shall cooperate with remaining investigation, shall not hamper or tamper with evidence. He shall not in any manner try to influence witnesses. Number 4, he shall not indulge in any activities violative of the NDPS Act. Full stop. And 4th condition, in case the petitioner has suffered any kind of drug addiction, he shall do the needful with the help of his guardians and family members for taking rehabilitation for recovery.
Obliged, Lordship.
The return the case diary, bail petition stands disposed of.
Obliged.
Allowed and disposed.
18.
May I please, your lordship? Diary was called for. Diary, I said,
So now, Punapur,
yes. FIR is page 7, my lord. Page 7. With due respect, I beg to state that about 1.5 years ago, the accused married me as per Muslim rites. It is pertinent to mention that the accused introduced himself to our family as unmarried one. The accused has taken rupees 25 lakhs from me on pretext of purchasing a vehicle and dishonestly misappropriated the said amount and cheated me. He also everyday physical and mental assault me for money. The accused also sexually assault me on several occasions without that is he threatened me of 10 talak if I am not agree to maintain physical relation as per his will. I have to bear all consequences just to continue my family life. It is come to know that the accused had been married another woman. I have no knowledge that he had married another woman.
There is no concrete evidence that with whom, my lord, again, he married.
Staying with their
I
house.
said in the beginning, we can give conditions, some conditions, so that it does not cause any, harm on her. Mr. Gogoi, Learned Counsel, BB Kotak. Actually, he is alleging some domestic violence in a sense.
Plus, some husband was some defiance that is there, my lord.
Even that law should be, all laws should be gender neutral, actually, ideally. For invoking 483 BNSS, the petitioner is seeking regular bail in connection with Apur PS case number 117 of 2026. Under so-and-so section. He was arrested on 7/8/2026. The FIR has been dated 7/8/26 has been lost by the victim woman stated to be his wife. She has made allegations of he's taking money from her and cheating, and also relations with another woman, semicolon, and also
One also allegation is also that by
and also of assault, full stop. Next paragraph. The case diary as called for has been received. So the on considering the matter, I'm of the considered view that subject to suitable conditions, the accused can be granted bail these days. Accordingly, 30,000 with one security satisfaction of the CGM Sonapur will be metro only.
yes,
And conditions that he will cooperate with the remaining investigation and he shall not commit any harassment, harm or threats upon the informant stated to be his wife. Upon the informant, bill petitions allowed and disposed of, return the case diary. Report.
22.
Last date also nobody had appeared.
yes.
Diary has come, no?
It should be received money.
The last date also, maybe they have some.
22.
22.
I heard it 32.
Hmm?
Sorry, Lordship.
You are appearing, no? This time. Today you are appearing.
You may kindly see the
20,
FIR
and
case number 14. Lordship.
Allegation lordship, pilferage lordship, crude oil. FIR dated lordship 8/2/2026.
Filling of this
Yes.
petroleum. Some organized activities are there, then it may not be justified.
Yes, yes,
Hmm?
organized activity. madam.
The FIR mentions that,
Yes,
but
yes.
it remains to be seen
Yes.
what has been found. Just a minute, I'll come to.
Along with one
Just a
Aditya Moran, they are the main, my lord. Accused. And there are criminal antecedent also there against the present accused person.
Just, lodged on behalf of Oil India.
Yes.
Oil India. Yes, what is your
That is the
submissions?
None of that lordship Tata Yudha vehicle lordship.
Hmm.
Just recovered, seized. lordship.
Along with this,
Yes, it's mentioned lordship.
35 numbers of fully loaded 50-liter gallons, considerable oil, 1750
lordship?
liters. 5
Lordship.
numbers of 50 empty gallons was also found. Mainly this 1750.
Lordship, may I see para 3 more for a moment. That vehicle was given to one lordship Raja Moran on good faith lordship for the purpose of carrying lordship goods.
There are 3.
Para 3 lordship, page 4. Raja Moran was the driver lordship. He was given on good faith lordship.
The petitioner is the owner of the
Owner of that
owner of the vehicle.
Then Raja Moran and one lordship Manos Khan
Owner
have
of the
already been
vehicle.
arrested and they were enlarged on bail lordship.
Let me see then. Para 3. no?
Para 3.
And you see his contentions then.
Yes,
He
sir.
said that
Other
he's
Raja
just given it
Moran-
on hire.
Raja Moran, that is, my lord, that is in respect of a different vehicle, that is the owner of the vehicle, Suzik Kisas. He allowed one, my lord, actually one main accused is, my lord, present petitioner and one Aditya Moran, my lord.
As per the
Then,
investigation,
yes,
he-
and my lord, regard the present accused person earlier also involved in one Bordubi PS case number 7/25.
then the things might be
Under
different.
same sections, my lord. 3032 BNS read with section 32B of the PDPP Act and section 15(2) of the Petroleum and Minerals Pipelines Amendment Act. And the present vehicle also involved at that time of committing the said offense. my lord.
Same vehicle.
Yes.
Then there might be some.
And police is now charging for the present accused. my
Then
lord.
may not be justified. Mr. N. Hassan, learned counsel for the petitioner, and P. Botagur, learned additional people. The petitioner is seeking anticipatory bail in connection with Barekpuri PS case number 2 of 26, so and so section. Full stop. The
Yes, to say-
allegations, the FIR was lodged from the Security Department of Oil India Limited with allegations about joint operation conducted along with Tinsukia police, whereupon 1750 liters of condensate oil was found along with empty gallons, hose pipe, and a Tata Yoda vehicle AS02CC 7389. Stop. The FIR alleges involvement of a well-organized nexus of gang in illegal pilferage of oil in this area. First, the case diary has been received. The learned counsel, Mr. Hassan, submits that the petitioner denies his involvement in the alleged offences and that he is the owner of the said vehicle mentioned in the FIR, which he had given in good faith to 2 persons named Raja Moran and Manas Khan, who were arrested in this case and later released on bail. Full stop. On the other hand, the learned additional PP on the basis of the investigation revealed through the case diary submits that, as alleged in the FIR, the investigation has also found involvement of a wider organized group in these kind of illegal activities, and that there are direct and significant implications as against the present petitioner. It is also submitted by the prosecution that the present petitioner has been found by the investigation to be one of the main persons involved in this racket, and against whom other criminal proceedings also pending. The given facts and circumstances, it may not be prudent to grant anticipatory bail to the petitioner, at least at this stage. The investigation is still going on. And such view of the matter, the bail petition stands rejected. Return at this stage, return the case diary.
Obliged.
This petition has been prepared under section 482 NSS method, paying for clearest to the petition. Connection with
Search sheet submitted, man.
petitioners, my lord, they are the family members, my lord. Already, my lord, the main accused, my lord, the husband of the victim, my lord, he has been arrested, my lord. He is till today, my lord, he is in jail, my lord.
Okay, what is the allegation? 498.
Dowry death, my lord.
82, my lord, 80 dowry death, my lord.
Then we have to see properly.
Present petitioners, my lord, happen to be the parents as well as the elder brother of the husband, my
Are
lord.
there any direct allegations against them also?
No, my lord. Their names have been inserted in the
daughter,
FIR
Rashmina
because
Khanum.
of the fact that they happen to be the family members of the husband. Interesting, my lord, there is a baby, male baby, my lord, aged about 3 years, my lord. That baby is with the petition number 3, my lord. His grandmother, my lord. The investigation has already been completed, my lord. The sheet has been submitted, my lord. Bail may be considered, my lord.
Their father-in-law, mother-in-law, and
And brother-in-law, my lord.
what
They are
the,
residing separate.
what is the take of the prosecution?
As per my instruction in this case, already search sheet submitted. No, scan copy
Yes.
of the TCR may be called for me.
Allegations are against all of them, actually.
Yes.
There is also allegation about, do you know the sections under which
Yes, say under section 80 and
homicide,
82, man.
homicide is given?
Dowry death. Dowry death, man.
Dowry death.
Dowry death.
Then it may be better to see the record.
Yes. The TCR.
Despite the,
Record date maybe.
so since the allegations are against all of them, the
They may be protected, my lord.
The
By receipt
petition-
of the NCR, my lord.
the petitioner is seeking anticipatory bail in connection with Barpeta PS 229 of 26 under so. The case arose out of FIR dated 25/6/2026, lodged by the father of the deceased, who was stated to be married to the accused number 1, Manwar Hussain of the FIR, who's not before this court in this bail petition.
He has been
and
arrested.
stated to be in custody already in full stop. The allegations are about demand of dowry and cruelty, accompanying cruelty, and eventually the family members of the deceased received information about her suicide, but it is alleged that they suspect that she was killed in a pre-planned manner. The case diary was called for, but learned additional PP submits that information has been received that charge sheet has been submitted in the meantime. Right, CS number
244/26 dated 24/8/26
under section
under section 85/82 of the BNS.
pertaining to dowry debt.
Yes.
Considering the nature of the alleged offences and that the fact that allegations were made against all the petitioners, all the family members of the husband as well in the FIR, would be prudent to have a look at the case diary and charge sheet. Accordingly, call for the scan TCR of so and so comprising case diary and charge sheet from the court of learned CJM Barpet. List on.
In the meantime, my lord, the male baby is with the grandmother, my lord. Petition number 3, my lord.
That we can
Should be considered.
This submitted that the deceased left behind a 3-year-old child who is presently with petitioner number 3. Petitioner number 3 stated to be
Grandmother of the
mother-in-law of the deceased, the child's paternal grandmother. Stop. It is directed that in the event of her arrest, in the interim, maybe 25,000 is considered.
Sorry to say, my lord, here, my lord, search sheet I will have to get the search sheet submitted only against accused, my lord, Manwar Hussain, my lord.
Yes, ma'am.
Oh,
So I will have to get instruction. Your lordship may kindly fix it tomorrow, my lord, whether in respect of the other accused persons, my lord.
Then we'll give interim to all of them.
Yes. Yes.
Probably
The learned prosecution clarifies that
probably they may be, my lord, they not cooperating with the investigation, probably because of that, my lord.
no,
Against
then they're not sent up for trial then maybe.
only against, my lord.
The
Anwar Hussain.
learned additional PP further submits that will change over to me. Conditions. But it appears that charge sheet was filed only against the husband.
This may
Though
kindly be kept
the
in the
details have to be verified. Will you, shall we call for the scan record? Or you'll take instructions, that's better.
Instruction tomorrow, my lord, your lordship.
Oh, very tight day.
It's very difficult, my lord. Already release has been published.
Against the present.
We'll fix it on Wednesday,
Yes.
Thursday. And
In the meantime, then
Yes.
we
allowing the prayer for interim bail. Yes, in the intervening period till the next date, it is directed that 25,000 each, 25,000 each. I'll do what how.
This report may kindly be kept as a part of the record.
The report from the IO may be kept with the case report, 25,000 each. Cooperate with the process of law, just this much, this is nothing. No. Let him take the
He may also call for the scan copy also regarding other accused person with.
No, we can extend the interim, you take the instructions.
Fine.
Suppose suppose
not
it is not, they are not sent up for trial, then no need to call also.
Yes.
Fix on Thursday. What will be Thursday? Which day? 3.
next
Three.
Thursday.
3.
Obligement.
এটা আছে তাহলে 26 এটা আছে
Lordship, on the strength of the interim, my lord, we appeared, my lord. And my lord, I am just placing 2 aspects, my lord. One is the Jimma order, my lord, was given, my lord, on the date of my lord, giving the statement, my lord, neither the vehicle was.
They are the owners of the
owners, my lord. Dada. And my lord would appreciate My vehicles, my lord, even the tires have been taken away, my lord. 6 of the tires have been taken. The batteries are taken away, my lord.
Because it was lying on
Yes,
the
my
road.
lord. We got the Jimma also, but they are not even giving us the Jimma. I've given the photographs also, my lord. On 24th, I went to give my statement, my lord. These things were there.
It has. Yes, Mr. Bosu.
Statement recorded, my lord.
Hmm?
Statement recorded, they said, my lord, they are the owners, my lord,
Oh, let
and
them-
they didn't know about the, my lord, the Sambats, my lord.
Two,
They have given it to, my lord, the driver. In that time, maybe, that was their statement, my lord.
two,
Otherwise,
4,
they,
5. No. This is a subsequent bail application. Earlier bail petitions were rejected on 12/12/2025 and 6/1/26. Stuff. The petitioners were granted interim bail on 19/8/26. In updated case diary call for, which is received. Mr. Boyce, learned additional PP fairly submits that they have appeared before the IO and contended in their statement that they were not aware of any offenses connected to the trucks which were owned by them. Investigation is also stated to have progressed, not completed, no? Not completed.
not completed, my lord.
The given circumstances should be just and proper to make the interim bail absolute at this time. Accordingly, it's hereby made absolute, subject to the same conditions to cooperate the remaining investigation. The remaining investigation and abide by the process of law. Return the case diary, bail petition stands allowed.
Deeply obliged, lords.
You can take the photographs if you want. We can plan that matter to your matter. Because you know, I was committed to in taking up the bails because it's primarily a bail bench, right? So there was some urgency. So it seems that you want to go back to Itanagar again because I am going from 7th 1 week.
Your lordship is going.
Yes. No need. You do it by video.
Lordship is Kohima or Itanagar? Kohima.
No. Change Itanagar.
Okay.
So you can because see tomorrow we tight not possible, and next 2 days, the next 2
Hardly 3 days
next week
we have.
I'll be unavailable. I have to some medical reason I have to go to Delhi.
Okay.
So 2 days I'll be attending court only on Monday.
Your lordship will.
You can do it by video, save some money for you.
Video is okay.
Video is also fine, Miller. Sometimes, Miller, there is some problem
I
with
would
the
have
connectivity.
hesitated, but because it's up to you. Just joking.
Too long.
I would have slightly hesitated, but since we have already gone into the matter,
Yes, ma'am.
video I'll be able to handle videos.
Fine, Miller.
That's what I leave it to you.
We'll do online, Miller.
I leave it to you and your clients.
Only my lord is this
But we should close it.
yes, ma'am.
Should not linger.
Only I'll take.
But otherwise, we could have done it tomorrow, next week. But next week, I myself have constraints. So thereafter, you can take, or if you have some difficulty doing it online or going there, then what you do, I've already told him. Then in that week, after I come back, we'll take a date, say 14 or something, and fix it at 2.
Fine, Miller.
Here.
Fine. Then primarily on 8th.
Then I will not carry the file. I'll keep it here.
It's not required. Fine. On 8th, lordship can take up, Miller. 8th of September, if not inconvenient. Yeah. Yes, Miller. There.
Always there. Option is always there. Monday.
8th will be Tuesday, Miller.
7.
Tuesday, but division bench is there. All there, as you know. Tuesdays are division bench also. But we still sit. Singles also we sit.
Yes, Miller.
But I don't know. The DV is longer because you have been waiting for this matter.
Let's try our luck, Miller. Because nobody knows how.
Take it on a single day. We'll do it at 2.
Yes.
Take it on a single bench day. We'll do it at 2. Because it's part third matter. It can have priority. Or after I come back from 14th week, anytime you take, you can take it on 15th. We'll fix it at 2 o'clock. Irrespective of bench, I can take it.
No?
15th, you can take it. We'll fix it on at 2 o'clock. Then also,
14
hearing day is better if I'm on single bench.
Hearing day better than 15, my lord.
15, then you can do it physically here.
Yes.
Hmm?
That will be fine, my lord.
Actually, my lord, I'll bring in scholarship, my lord, on 14, my lord. So whether I'll return.
Won't be able to. Scholarship is roads
Yes,
also.
yes, my lord. So
Mhm.
already fixed, my lord. There are 4 cases fixed there, my lord. So 16, my lord, believe.
17th.
17 some difficulty. 16.
You
my
have
lord.
some difficulty.
16 because High Court matters will be there on 17, my lord.
16,
No, why I'm saying, because suppose we have a bench like this, suppose with long list, it's a motion day, lot of bail hearings, then
That's
2
the
o'clock
problem.
again, it will disrupt.
That's the problem, my lord.
You'll also not feel comfortable maybe.
That's true.
But then,
14 তারিখে রাখো না।
same thing.
17, no.
রাখি দেখো, ঠিক আছে।
17, my lord.
Also will keep on 17, huh?
17. 17, 2 p.m.
Fine, man.
The paucity of time matter could not be taken up today. So the matter is proceeding as part her. Full stop. List the matter on 17/9/2026 for remaining hearing at 2 p.m.
Fine, man.
On priority, we'll do it and finish it.
Fine, fine.
My senior friend, my lord, complain, I'll take my lord down only 1 hour, my lord. Not. It is a maintainability part, my lord, I'll reply, my lord.
1 hour is also not less.
Highly obliged.
ফটোটা হেও 2 p.m. to mention করে দেব বলতে মেনশন হয়েছে এটা আছে
May I please alert? My lord, here two petitioners, their husband and wife.
Okay, this matter.
FIR starts
Your
from,
affidavit has come in the record, Mr. Agrawal, in the meantime.
FIR starts from 14, my lord, and relevant portion page 18. Here, my lord, as per allegation, these petitioners, my lord, procured 2 birth certificate of their child, my lords. Page 18, my lord, allegation part.
Just a minute. Page
Page 18, my lord, relevant portion of the
18.
180.
What is the case about actually?
The case is that, my lord, petitioner before your lordship, my lord, number 1 is a lady. She is a elected, my lord, Gau Panchayat president, my lord. And petitioner number 2 is her husband. As per the allegation that, my lord, she procured 1 birth certificate earlier and 2nd birth certificate later, my lord, to show that, my lord, she was married when she was major, my lord. He is apprehending that, my lord, if her birth of the child is shown earlier, then she would be, my lord, proved as a minor when she was married, then she would be disqualified in the post of, my lord, Panchayat president. It is their allegation, my lord, but fact is not that, my lord. And here, my lord, they also alleged in the, my lord, FIR, last portion, my lord, page 19, paragraph 5, my lord, that this birth certificate she also produced in a writ petition being WPC number 957/2026, my lord. But this writ petition is subsequently, my lord, withdrawn because of alternative remedy is there with her, my lord. But there was nothing, my lord, adverse remark was there in this when, my lord, this writ petition was withdrawn, my lord. And in this regard, my lord, I have already submitted 1 additional affidavit. And in the affidavit, my lord, I have also taken the plea that, my lord, how this writ petition, bail application, FIR was not maintainable, my lord, which is legally barred, my lord. Because now, my lord, as per section 215 of BNS 2023, my lord, whenever, my lord, any document was tendered before the any court proceeding, my lord, this is the only the prerogative of that court, my lord. If it is not correct, my lord, this court will, my lord, direct to file FIR, my lord. Then that will go in accordance with law, my lord. Here, as per their own, my lord, allegation, they have filed two complaints, my lord. One before the deputy commissioner to get her disqualified from the post of.
That goes like a complaint case, I think, 340 CRPC.
Yes, my lord. But
I
prima
have to
facie,
brush up, I've forgotten.
as per section, my lord, 215, my lord, this FIR is not maintainable. Because as per their own allegation, my lord, they have filed two complaint before the deputy commissioner to get her disqualified, my lord. There are, my lord, Panchayat Act provides that, my lord, to remove any, my lord, candidate from the post of, my lord, Panchayat after election, my lord. Only remedy is the, my lord, election petition, my lord. But this time is already 60 days is over, my lord, as per Panchayat Act, my lord, section 127. Therefore, my lord, they are, my lord, indirectly, my lord, filing cases and FIRs, my lord, trying to blame her and remove from her post.
Just a minute, let me see the, I'll just go through your affidavit, just one minute.
I summarize the facts once.
Just a minute. Look through it.
Case is already, my lord, started.
She was married to whom?
My lord, petition number 2, my lord.
Two, husband, wife. Okay.
Listener number 1, she is a member of a Gaon Panchayat president. Basically, he got elected. She signed. There's a panchayat rules which bar a member person who falls under the category of child marriage. If anyone who is done a child marriage, they cannot contest an election. Now, as per the rules, they have to file and submit an affidavit. Now, I am her constituent. I go before the DC and I lodge a complaint. All bona fides. I come to know that she got married, she violated the rules of the panchayat, and she misled the election process. The DC, the honorable district commissioner, they take cognizance, they issue notice to the petition number 1. Now, instead of submitting before the jurisdiction of the landed district commissioner, they file a writ petition for quashing of that proceeding before the Honorable Gauhati High Court by relying on a fake birth certificate of her son. I filed in that I was a
Fake birth certificate of her son.
Son
Who was born subsequently.
Yeah, birth certificate. Now I was a respondent in that case. I filed a written reply, and I also filed an RTI. To which it was prima facie said in the RTI reply that this certificate is fake. That is also there in the charge sheet. Now, when I brought this to the notice of this honorable court, they withdrew the petition. Subsequently, I filed and lodged an FIR. In FIR, that is the FIR before why they have sought anticipatory bail. Now, in the when FIR was lodged, my lord, there the police took a cognizance under of fake forgery and subsequent of misleading and evidence. So, my lord, subsequently POCSO was also added and PCM was also added. But as far my knowledge is, I have gone through the charge sheet. The POCSO section was removed later on.
Only PCM is there.
Yeah, your lordship will see.
And forgery is there.
Forgery is there. But now that is a very serious offense. Now they will kindly see the character of the person who is. A, they have violated the public trust. But they are the elected representative melons, and I am the constituent melons. I have full authority melons and lodge a complaint melons. So they, instead of submitting before the district commissioner, they come and they so there is one they file a fake affidavit. There is a first offense. Second offense, they get the fake birth certificate. Then they, after opening that birth certificate, they come for quashing to mislead the court, Honorable Gauhati High Court, Honorable this
In
court,
the writ petition.
in the writ petition. So there is three distinct offense violence. Now whether they deserve the anticipatory bail or not, and my lords will see in the charge sheet, my lord, all attempts were made by the police, my lords, to arrest them, but they were absconding throughout, my lords. That is, my lords, one. My lords. The other is on the submission on the bar of the.
Kindly address on them.
That is, my lords, the constitutional bench judgment is there, my lords. I'll be placing before my lords.
A document which is already in the custody of the court.
No, my lords. That is the bar is only there when the forgery is done before when there is in the custody. The forgery already happened.
No, that's what I'm saying.
Yeah.
Custodial legis or some
Yeah,
term is there.
custodial, that is there, my lords. Yeah.
So custody of the court.
Yes,
And
it is
thereafter,
already charge sheeted, my lord.
thereafter, the forgery is committed. In that case, complaint case would lie,
Yeah.
not a police investigation.
Yeah, but this is case a different case.
This, so if a document is already forged
Yeah.
and then submitted,
Yeah.
then
a police FIR will be lodged.
will lie.
I lie. The relevant para is
Iqbal
para,
Marwa, this
para
case-
33 minutes. It's a constitutional bench judgment, 5 judges bench minutes.
recollecting.
From para 33 minutes, the entire observation is there. May I read minutes or it's
Yes, we can just glance through.
Yes, my lord.
Glance through.
In the view of the decision above made, we
para?
are of the opinion that Sachan Anand Singh has been correctly decided and the
Para,
view-
please. Para.
Para 33 minutes.
Just a minute. Yes. In view.
In the view of the decision made above, we are of the opinion that Sachid Nanat Singh has been correctly decided and the view taken therein is correct view. Section 195, 1B 2 CIPC would be attracted only when the offence enumerated in the said provision have been committed with the respect to a document after it has been produced or given in evidence in a proceeding in any court during the time when the document was in custody. In the present case, the will has been produced in the court subsequently. It is nobody's case that any offence as enumerated in section so and so was committed in respect of the said will after it had been produced or filed in the court or district judgment. Therefore, the bar created by so and so would not come into play, and there is no embargo on the power of the court to take cognizance of the offence on the basis of the complaint filed by the respondent.
There is also at least one decision of our court also, where of course this is the law laid down by Supreme Court, but in one of our High Court decision also this aspect was discussed in detail. I think 340 and applicability, if I'm not, my memory serves me right. But this is the law.
This is
no?
the constitutional bench judgment. In these circumstances, when the not once, but not twice, but thrice, thrice they have, and they come from a position of a very influential position,
This case is at the stage of trial.
Trial one.
Charges has been filed. On my minutes now, please come to my affidavit in opposition, minutes. After they, so initially they were also granted interim bail by the learned additional district judge Dhubri, POCSO, learned special judge. Subsequently they appeared also. On the day they got interim, on the very same day they threatened me also. We live in the same area, and I categorically make that statement to the IO, and I also lodged a complaint, miscellaneous case number 585 of 2026, and exam 1 minutes. They are come from a very influential position, a very powerful person.
They can appear and take bail from the trial court also.
Let the trial court decide, because
since the doors of this court has been knocked, I'll take a call. But that option is also there.
Yes, yes.
Because now at this stage of the trial, I mean,
but they have
keeping them in custody also won't serve much purpose. At the same time, you may be right. If suppose I have to see, of course, cross check. If this is your projected conduct, this is what you are convinced about that, then pre-arrest may not be justified also. At the same time, so actually, the special court may be best placed to decide at this stage. But still, we'll decide. We'll take a call on this, as I said.
Only thing is that, my lord, they have filed 2 complaints before the deputy commissioner, my lord, and all the documents are, my lord, seized, my lord. And this complaint petition is also cognizance is taken by the deputy commissioner, my lord.
Matter of trial now, they'll have to face it.
Only, my lord, lady person, my lord, and
responded
representative.
throughout the list.
No, my lord, always we are all along, my lord, we are fighting
The
for
note by
bail,
the
my lord.
charge sheet.
And she is also admitting, my lord, and still we are before your lordship. And they will face, my lord, trial, my lord, documentary evidence, my lord.
Okay.
As well as, yes, since learned additional, learned.
Their latest complaint, my lord, page 46, my lord, annexure 1 in their edition.
Latest complaint means?
And another, my lord, this is before the district magistrate complaint is.
They have threatened us, that is the complaint. In my additional affidavit, in my affidavit in opposition.
I'll see it.
This is also just one thing was might consider, Manoj, that since a learned district judge, Manoj, they will be best placed to understand the local issues, Manoj. So I think that is also something, Manoj, because the case was never decided on merits. The learned POCSO judge, just one second, learned POCSO judge dismissed the case on jurisdiction issue. So on merits, it was never decided. So I think that is also one approach my lords can take. Grateful, Manoj.
So, London, my lord, district judge said that, my lord, there is prima facie, there is no element of, my lord, POCSO. Therefore, it was declined to entertain.
Also, you said.
Yes, sir. Therefore, my lord, it was.
Also, I'll give it in the.
Grateful, Manoj.
About it. We're almost done. Other matters, what is the order matter?
So it was last, my lord, bail matter.
Huh?
It was last bail matter.
Yes, I know. No, there's one order matter. Take another date if it's, or if there's something very urgent, you tell me. 28. Admissions are almost all adjourned.
28.
Yes, yes.
That means service is complete upon response number 2.
I am appearing for the response number 2. My name may be shown in the
28.
to
28?
file objection, my lord. 3 weeks time may be granted.
28.
It is for maintenance matter? What is it?
No,
Not
madam,
maintenance.
it's order framing. We have challenged the order framing charge, madam.
Oh, framing charge itself.
Yes, yes.
Third to लिख दिया अभी. Madam entered appearance on behalf of son number 2, the informant. Informant. And you'll be filing a.
I'm going to file.
Okay. And,
Customer already filed.
and 2 weeks time? 3 weeks time to file file an affidavit objecting to this petition filed by the petitioner against order dated so and so. Order dated 18 to 26 past in sessions 14 of 24 by learned additional session judge number 2 Nagaon, framing charges against the accused petitioners. Accused petitioner against the accused persons, including the present petitioner here. The prayer for time is allowed. We'll scan record is available. So yeah, after you file, we can take it up. Okay. This is the matter after 3 weeks on a date to be fixed by registry. Oh.
It may
Admission or nahi? Admission so the adjourn question. No. Okay. You have some matter? Time.
Kindly fix a date, it will take some time, Lordship, my senior will. Jimma petition for cash, Lordship.
Jima,
Jimma, Lordship.
voluminous reports. It involves some complicated issue.
The cash was seized.
PMLA, it seems.
But that section has been omitted now, Lordship. Section 4 was there. Now that is
Yeah,
omitted. Final report has also been submitted by the IO.
Your good name, please?
P. Dole, Lordship.
P. Dole, learned counsel appearing for the petitioner. The matter could not be taken up today due to paucity of time. Record has been received and tagged with the case record and tagged with the file. List after 3 weeks.
And Lordship, may kindly fix a date.
You can suggest then.
11th of September, public.
11/9.
Public.
It will remain in admission stage.
Lordship.
In the admission column.
Adding it in 29.
Hearing nothing.
Lordship may fix a date, Lordship.
I didn't realize the hearing were remaining also. You are for the appellant?
Lordship.
Bodole. S. Kotoki, learned counsel, hearing for the appellant, convict appellant. He's in custody.
Lordship.
So you are appearing for the informant. You are for the Mr. Bushra for additional PP, and your good name, please, madam. P. Sharma, learned counsel, appearing for the respond number 2 informant. We can manage without this paper book, I think.
Yes.
How many witness? Any idea?
7, Lordship.
The original case record is available. Hearing could not be done today because of paucity of time. So you can take a date.
I may suggest, Lordship, 10th of September, Your Lordship.
10th of September. 10th is Thursday. Oh, 10/9.
Obliged.